Trump's Attorney General William Barr has blown past a key deadline House Democrats set for releasing the full Mueller report. This tees up a major fight with the very top lawmaker on this issue, House Judiciary Chairman Jerrold Nadler. And we begin the beat tonight with the very legislator overseeing the DOJ and leading this fight, Chairman Nadler. Given all the news, I want to get right to it. Thank you for coming on the beat, sir.
Thank you for having me.
You run the Judiciary Committee. Attorney General Barr has missed your deadline. How will you respond?
Well, we've noticed a markup. We're having a markup tomorrow morning in which we will vote to authorize the chair to issue subpoenas, for the Mueller report and for the underlying materials and for various documents to 5 other people.
So you're going right to it. You have this vote tomorrow. If you win that vote, and as chair, I think you expect to, when might you then actually issue the subpoena for the report or for those individuals?
Well, we will, for the individuals, we'll probably issue them right away, but for the report and the underlying materials, we'll work with the Attorney General for a short period of time to get the report. Now, he has said he'll release it by the middle of the month, which is 2 weeks. So that's not really the issue. The real issue is we want to see the entire report, not a redacted version, and all the underlying materials.
So to understand you right, tomorrow you immediately move forward on issuing the actual subpoenas for those 5 people that your committee has identified?
Well, shortly.
Or shortly thereafter. Whereas the other subpoena, the report subpoena, you sort of use that as that's the planned leverage to see what he does with the redactions?
Well, it's to authorize us to negotiate with him and not to negotiate with him, to work with him and to minimize the redactions. And we'll use the subpoenas as necessary to make sure we get the whole report and all the underlying documents.
Understood. So that sounds like some legal muscle. I want to get into the redaction details with you because it seems to be where, according to you and some other experts, this whole fight is heading. Before we do, I want to give you the benefit of responding to what I know you're aware of. The president today claiming this isn't about the substance of the report, but a kind of an old beef between the two of you. Take a listen.
Nothing you give them, whether it's Shifty Schiff or Jerry Nadler, who I've known, he's been fighting me for half of my life in Manhattan. And I was very successful, thank you. But Nadler's been fighting me for years and years in Manhattan. It's a 400-page report, right? We could give them 800 pages, and it wouldn't be enough.
Mr. Chairman, have you been fighting with Mr. Trump for years? What is your response to the core accusation that this is about that and not the substance?
That's absurd. The president is very small-minded. Yes, we had clashes about some developments on the west side of Manhattan many years ago, but so what? What's relevant now is that I'm the chairman of the Judiciary Committee, and we have a job to do, which is to protect the rule of law against obstruction of justice and abuses of power and personal enrichment, and we have to do that job. And the fact is, there was an investigation for 22 months, and now the Attorney General in 4 days, an Attorney General who auditioned for his job by writing essentially that the investigation was wrong in itself and that a president could never commit obstruction of justice, which is an extreme view. And so he's not the proper person to oversee this or to decide what gets public. And we have to see all the material and the underlying, to see the report and the underlying documents to protect the public and to protect the rule of law. And remember, however the president may characterize the Mueller report, according to what Barr said, because we haven't seen the report, found wrongdoing and that we don't even know, that it is not public, and found a lot of very serious things. And the special prosecutor said that he couldn't rule in or out, he couldn't exonerate the president of obstruction of justice. So Barr took it upon himself to do that.
Right.
But that's not the job of the Attorney General, who is, after all, a political appointee of the president. And the Justice Department cannot hold the president accountable, both because of their doctrine that you can never indict a sitting president and because of Barr's memo that said that the president cannot commit obstruction of justice. So Congress must hold the president accountable. And to do that, we need all this information.
Yeah, so Mr. Chairman, you've heard all the information. This seems to be where the fight is going. As you say, many in America waiting to find out what Mueller found. You posed a question that Senator Feinstein read at Mr. Barr's confirmation hearing about transparency. Let's take a look, because it's so central now, at that brief exchange.
I have two questions from the chairman of the House Judiciary Committee. Will you commit to making any report Mueller produces at the conclusion of his investigation available to Congress and to the public?
As I said in my statement, I am going to make as much information available as I can, consistent with the rules and regulations that are part of the special counsel regulations.
It seems that with your coordination with Senator Feinstein, you got him under oath on record there on a standard. And so I want to get into this with you tonight. And I think our viewers are very interested in this, Mr. Chairman, whether or not, as we put up on the screen these 4 redaction material categories that he's proposed, do these fit his standard? He says, as you know, in his letter back to you, that he's now made it 4: grand jury, intelligence, open investigations, and what he calls matters that impact the privacy or reputation of, quote, peripheral third parties. In your view, has he gone now and partly failed the standard that he committed to under oath, which was the rules, or do you think the rules do require these 4 categories of redactions?
Well, first of all, the rules are regulations of the department itself, which he can change at his whim. But second of all, and more important, it's a meaningless statement. He said he would release to the public, he would release everything he could. But he reserves to himself the right to make those judgments. He put into the letter to me these 4 categories. All 4 categories, there is ample precedent, ample court and other precedent for releasing all this information of all these categories to Congress. And that's what we're asking. We have to see this information to protect the American people. And it has to be the congressional judgment. For example, the Congress knows how to handle classified information. Mm-hmm. The Congress can very well handle and has handled 6E information. In fact, in every previous condition, in every previous analogous situation, whether it was with Jaworski in the Nixon era or Ken Starr or various others, the Iran-Contra, Congress has received all this kind of information. So we're simply asking for the same thing.
Let me ask you this. Do you think in some sense he is sort of hiding behind the rules for wider redactions that he may want to make?
Absolutely. He's hiding behind the rules and the redactions. Listen, he auditioned for this job. Remember, the president got rid of Sessions as Attorney General because he wouldn't protect him. He fired Comey because he wouldn't protect him and give him the loyalty he wanted. He tried to fire Mueller. He clearly wanted, and he said he wanted an Attorney General who would be his Roy Cohn, who would protect him personally. Barr auditioned for the job by writing that 19-page memo in which he basically said that a president could never be guilty of obstruction of justice because a president, period, couldn't be no matter what he did. So he was chosen. He is the president's agent, and he is not in a position to make independent judgments that the public can trust.
So let me ask you, Mr.
We
Chair,
have to do that.
Since you make the historical comparison, I earlier played you a rather non-substantive argument from the sitting president, and you rebutted it. I want to play for you the more substantive argument, which doesn't come from President Trump, but from his lawyer and his chief of staff, where they say, basically, you might be right that that's the way it used to be, but the rules have changed, and they do give the AG more power. And I know, being the constitutional expert you are, you're familiar with this. For everyone, I'm going to play their response for your rebuttal. Take a look.
The special counsel reports to the Attorney General of the United States. That's different. And then there's a specific regulation that governs what confidential report is delivered not to the United States Congress, but a report that first goes from the special counsel to the Attorney General.
Mr. Barr gets to handle this. That's how the law works.
Are they wrong?
They are right and they are wrong. That's how the regulations work. But Congress still has the constitutional responsibility of protecting the rule of law, of protecting against abuses of power on the part of the executive, on the part of the president, protecting against obstruction of justice. Not necessarily criminal obstruction of justice, but obstruction of justice in the normal sense of the word. And for that, we need this information. And we have and Congress has a right to get this information in order to protect the American public and to do our job. Now, we should make as much of that as possible public, but we know how to handle. Congress knows how to handle classified information, knows how to handle other information. And for example, his largest category probably is information that might be deleterious to third parties.
Yeah.
To third parties. Well, that's a consideration. But a bigger consideration is the protection of the public in an issue of such public interest and importance.
And you spoke to the Attorney General.
And courts have ruled in that.
When you spoke to him last week, did he define what peripheral third parties means?
No, he didn't. We got that letter shortly after that conversation. He did not define that, and he cannot be allowed to define it for himself. Congress has to see all this information, and we can make those determinations. That's our job. Remember, the Department of Justice, both because of its doctrine, its opinion that a president can never be indicted, and frankly, because of the Attorney General's memo that says that a president can't commit obstruction of justice by definition, cannot hold the president accountable.
Right.
The only institution that can hold the president accountable is Congress. And we have a constitutional responsibility to do that,
right.
And the Constitution and the public depends on us to do that. And that's why it is important for the public welfare that all this information be shared with Congress, as it has been in every previous instance.
Well, it's interesting to hear you put it that way, because when we had the president's lawyer, Mr. Sekulow, on, we had that exchange, and he talked about how that other law sunset. But we went back and forth on the question of, well, the Constitution didn't sunset. I want to read another thing to you, and then I'll let you continue. Mr. Chair, we read your letters with great interest, and we observed that in one that you wrote to the DOJ before the Mueller report come out, you referred to basically the declination decisions. You referred to the idea that basically there's a question about whether Mueller tells Barr who he charged and didn't charge. And then do you guys learn about that? So I want to get on the record tonight, having you here. In your view, has Barr satisfied that? Has he relayed that to you? Should he? A list of people who were not charged?
Well, he certainly hasn't relayed that to us, and yes, that is part of the regulations, as part of the minimal thing that he has to tell Congress. He can tell Congress a lot more, obviously. But again, remember the key issue here. The key issue is that the Mueller investigation took 22 months. Barr summarized it, or issued his outline of it after 4 days. He is an interested party. He's a political appointee of the president. And we cannot trust the disinterestedness of his analysis. And to protect the public and to protect the rule of law, we must have this information. We must have the entire Mueller report and the underlying documents.
Right.
It's as simple as that.
And lastly, before I let you go, I want to play a little bit into our Wayback Machine. We've talked a lot about the history and what does it teach. This is something we found where you were talking about a situation in the Starr example where they had shipped over, as you're demanding now, all of the evidence, and then there was a debate over the timing over what Congress might redact. Let's take a look.
This was a rush over the weekend, and what was the rush? There was certainly not enough time even to discuss adequately the proposed redactions. For example, the Democratic staff proposed 27 redactions that the Republican staff didn't agree to.
In your view, what's important about that example? That was a debate about both timing, you used the word rush, and who makes the redactions in that instance, Congress.
Well, no, it's a more fundamental debate. It's being used hypocritically by the White House now to say, hey, haven't you changed your mind? In those days you wanted redactions, now you don't. Then the entire 445-page Starr report had been shipped over to Congress with all the supporting documentation. Congress had everything, and the question was how much of that was going to be made public and what had to be redacted to protect individuals or whatever in terms of the public. But Congress had everything, and Congress was going to make that decision. We are demanding the same thing. We are demanding that Congress get all this material, and Congress can decide if any of it has to be withheld.
But when you put it like that,
that had already been done.
Right.
So
when you put it like that,
discussion.
Mr. Chairman, it makes it sound like, okay, Congress could make that decision again, and if the report is so good for the president, why are his appointees fighting so hard to redact it?
Well, that's exactly right. If the report is, if you want to be very cynical about it, if the report is very good for the president, they'll release it. They'll release it to Congress and they'll release it publicly. If the report is very bad for the president, they won't do that. They'll try to hide it. And we know that there are things that we know because Barr said so, that there were negative actions, criminal actions that that the public doesn't know about cited in Mueller's report. We know that Mueller did not make a recommendation as to whether the obstruction of justice arose to a criminal level or not. Barr made that, and that's not his decision to make. But again, 20 years ago, all the entire report and all the material was given to Congress. That's what we're asking for now.
Chairman Nadler, as you prepare to embark on the rest of this legal sparring and issuing, as you say, the vote to authorize subpoenas tomorrow, I really appreciate you coming on the beat to share your views tonight.
Well, thank you for having me.
Thank you, sir. We turn now for reaction to Washington Bureau Chief for Mother Jones, David Corn. David, what jumps out to you about both the arguments the chairman makes and what it means to have the Democrats moving forward on a subpoena tomorrow?
Well, I think the subpoena issue will probably, work itself out in some way over the course of the next few weeks. I mean, if they have to rely on the subpoena, it could end up going through the court system all the way up to the Supreme Court if the White House and Bill Barr just say no and refuse it. To me, an interesting point here is whether or not there are redactions, whether Barr tries to redact portions of this, either for legitimate or illegitimate reasons. The argument that Congress should see all of it so they can evaluate the redactions is, to me, really important. And that, you talk about checks and balances and the vetting process here and making sure that Barr's not doing anything under the table, because there's a lot of reasons to be suspicious of his role in all this. Being able to get eyes on the full report and look at the grand jury material, look at the classified material, even if in some sort of classified setting, I think is key if there are significant redactions.
Take a listen to what Donald Trump said outlining his defense on all this today.
Well, I think it's ridiculous. The Attorney General now and the Deputy Attorney General ruled no obstruction. They said no obstruction. And so there's no collusion, there's no obstruction, and now we're going to start this process all over again? I think it's a disgrace.
Do you see any tells there in the way he's outlining his legal defense?
Everything with Trump is a tell in a way. I mean, he said not too long ago that he thought the report should just be released, and now he's not in favor of that. Why? Does he know what's in it? Or is he just scared about what's in it? The bottom line here is that whether there was collusion or not, he engaged in very suspicious activity during the campaign.
There was not chargeable conspiracy.
Right. Whether there was a conspiracy, a criminal conspiracy or not, or direct collusion, whatever you want to call it, he still engaged in very suspicious activity in denying a Russian attack was underway when it was underway, and having key people in the campaign interacting with Russians while the attack was underway. So that's really, if there is no direct conspiracy, those are the things that presumably Mueller investigated. If not, Congress still should do that, because that's where the American public deserves more answers than Trump has been willing to provide.
Well, we had the Judiciary Chairman driving this fight and breaking some news tonight, and David Corn with expert reaction. Thank you as always, sir. Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.